Thank you.
Thank you, sir. Thank you for your kind introduction. Good morning, very good morning, ladies and gentlemen. First thing first, this is not what I prepared for this session. I'm talking about the PowerPoint presentation. Thanks to my colleague, Ms. Bhagya Vikramasinghe, and our student, Shemal Fernando. Within few minutes, they worked out this work for me. I did my PhD and LLM in Computer and Communication Law. While I was doing this, my professor in computer law always told us, never trust computers, trust people. In the very beginning of our first session, I got a problem with my presentation slides. However, now I have one for you. This is the research topic, the role of a judge, what it is and what it ought to be. The independence of judiciary and judicial activism clothed in judicial review in Sri Lanka. It does not necessarily mean that I'm not going to discuss one particular jurisdiction. Wherever and whenever possible, this research will focus on to examples in other jurisdictions all around the world. Some of those other jurisdictions are enjoying the concept of apex judiciary, which provides more flexibility over judicial reasoning process. This is what we don't have in Sri Lanka. The lack of operation of apex judiciary in domestic jurisdiction mimics the flexibility of judges. One side of the flexibility of judges consists of the judicial review and other side consists of the judicial activism. The both are fueled by the concept of independence of judiciary. Therefore, lack of one of them highly affect to the independence of judiciary, which vehemently confirm the right of the people. Being a legal research, it is strongly recommended myself providing possible interpretations for the key elements of the paper. As you all are well aware, being a lawyer, being a law academics, our profession thoroughly depends on the interpretation of the words. So we should find a proper interpretation for our research terms. Independence of judiciary. As adopted by the 7th United Nations Congress on the Prevention of Crime and the Treatment of Offenders, which was held at Milan from 26th August to September 6, 1985, and endorsed by the United Nations General Assembly Resolution 40/32 of 29th of November 1985 and 4146 of 13th December 1955. There are 6 basic principles on the independence of judiciary. They are as follows. Number 1, the independence of the judiciary shall be guaranteed by the state and enshrined in the constitution or the law of the country. It is the duty of all governmental and other institutions to respect and observe the international independence of judiciary. The second one, the judiciary shall decide matters before them impartially on the basis of facts and in accordance with the law, without any restrictions, improper influences, inducements, pressures, threats or interferences, direct or indirect, from any quarter or for any person. Third one, the judiciary shall have jurisdiction over all issues of a judicial nature, shall have exclusive authority to decide whether an issue submitted for its decision is within its competence as defined by the law. Fourth one, there shall be no any inappropriate or unwarranted interference with the judicial process, nor shall judicial decision by the courts be subject to revision. This principle is without prejudice to judicial review or to mitigation or communication by competent authorities of sentences imposed by the judiciary in accordance with the law. Fifth, everyone shall have the right to be tried by order courts or tribunals using established legal procedure. Tribunals that do not use the duly established procedure of the legal process shall not be created to displace the jurisdiction belong to the ordinary courts or judicial tribunals. Last one. Sixth, the principle of the independence of the judiciary entails the requires the judiciary to ensure that judicial proceedings as conducted fairly and that the rights of the parties are respected. Last one. It is the duty of each member of the state to provide adequate resources to enable the judiciary to properly perform its function. The gist of the aforementioned basics emphasizes that the principle of separation of powers provide the basis for the judicial independence, which means that the judiciary, which consists of composition and proceedings, need to be kept away from the influence of other limbs of the government. Those are legislature and executive. Judicial activism. When the Supreme Court and other judges are able to creatively interpret or reinterpret the provision of the Constitution, there is judicial activism. This is to be believed something beyond the contemporary role of a judge. The reverse engineering of this argument is that legislative actions and executive actions are subject to active review by the judiciary. This is the point which connects judicial activism with judicial review. The concept of judicial activism is the polar opposite, the totally opposite side of the judicial restraint. This is what we are practicing in Sri Lanka at this moment. However, still Sri Lankans are enjoying some considerable level of result of judicial activism thanks to the creativity of bench and the bar. Preserved cases under the Chapter 3, for example, Fundamental Rights of the Constitution 1978, are solid example for the creativity of the bench and the bar of the Sri Lanka. For example, I would mention some cases: Vimal Fernando versus Sri Lanka Broadcasting Corporation, Karunatilaka and others versus Dayananda Disanayaka, Commissioner of Election and others. Both of these cases believe and accept the right to receive information. Now, judicial review. The principle of parliamentary sovereignty is a weakened arm against the unlawful executive and administrative actions or sometimes legislative actions themselves. This means that the principle of parliamentary sovereignty is not always to stand against the breach of rule of law. In 1950s, Stanley D. Smith in his doctoral thesis stated that it has become clear that judicial review is not merely about the way decisions are reached, but also about the substance of those decisions themselves. The fine line between appeal on the merits of a case and review still exists towards a culture of justification. The justification culture has been developed on the lack of judicial review. The concept of judicial review has been justified by the notion of qualities of the democratic society. However, judicial review of statutes on constitutional grounds tend to raise issues of high political importance. Quickly, I want to move to the problem of this research. This paper has already emphasized the threads and turns to the independence of judiciary and judicial activism coupled with judicial review. So, this is the basic or the gist of the research problem identified. The role of judge extensively depends on the opportunity for the judicial review, which fueled by the judicial activism. All of them collectively denote the independence of judiciary, which finally enhance the creativity of judge. The creative decision or judicial reasoning, which creative steps stand to protect rights of the people. The lack of one of them or collectively all of them eventually generates less protection of people's right. Sri Lankan scenario. Through the judicial officials in USA and India are enjoying the concept of judicial review. In Sri Lanka, special Sri Lankan bench do not have such a benefit in order to stand for the rights of the people. For example, Article 80 subsection 3 of the Constitution 1978 state that where a bill become law upon the certificate of the President or the Speaker, as the case may be being endorsed thereon, no court or tribunal shall inquire into, pronounce upon, or in any manner call in question the validity of such act on any ground whatsoever. The other example is Article 120 of the same Constitution. It clearly states that the Supreme Court shall have sole and exclusive jurisdiction to determine any question as to whether any bill or any provision thereof in inconsistency with the Constitution. Therefore, judicial review ends up with the bill stage at the legislative process. All creative measures need to be done before being passed the bill. However, literary, the concept of independence of judiciary stand with the Sri Lankan judiciary. For example, Article 107 to 111 of the 1978 Constitution. This shows that there are some differences between the literary meaning of the independence of judiciary and practical aspect of the same. The Constitution itself takes precautions to place the independence of judiciary, but still there is a lacuna to be filled with compared to the practicality of the concept. These are the recommendations. There are basically three recommendations. Need to set up a constitutional mechanism to work out composition of the judiciary, especially the post of Chief Justice. An independence public commission made up of persons enjoying national and international repute could be put in place to inquire into any errors made by the legislature, the executive and also the judiciary in the process of impeaching the Chief Justice, and how such errors could be avoided in the future can be put in place. The second one, Chief Justice could be accorded the opportunity to face an impartial judicial panel and to review a just ruling. Such an independent determination should be in accordance with the Article 14 of the International Covenant on Civil and Political Rights. Third one, to enact required legislation to establish a tribunal consisting of 3 persons who served in the apex judiciary or apex courts of any country of the Commonwealth to inquire into the misconduct of judges of the Supreme Court as was proposed in the draft constitution of 2000. Thank you.